court reporter, and I'll call this case number 048-322-624-21, Joshua Knight versus Texas Department of Criminal Justice et al. And this is, Judge Evans had set this matter for a status conference because of some, I guess, confusion on your part as to whether citation of service has been served on the defendants in this case, and you're filing a number of motions. And I'm Senior District Judge R.H. Wallace. I'm sitting by assignment today in the 48th District Court for this matter. And we are on the record. We're conducting this by Zoom hearing, and Mr. Knight is present, and of course, also the court reporter and I are present. The reason that I know I've looked through this file, Mr. Knight, before the hearing today to try to get a feel for what was happening, and I know you think you have been able to serve the defendants, but in fact you have not served them in any manner recognized by law. First off, Rule 103 of the Texas Rules of Civil Procedure sets out who can serve citation, any circumstances under which you can personally do that. The person interested in the lawsuit can't serve citation. So I assume that was you in the video that, I don't know, was that down in Austin where you handed some papers?
That was in Fort Worth. After I got those citations, I did send them down to the Austin constable and everything, and I talked to Tiffany eventually whenever they finally got around to it, and she said it would count as a reservice, which is why they haven't done it now, because I told her, like, I delivered it and that they have copies in their email and stuff like that, and she was like, yeah, that would be reservice. If you want to reservice them, that's on you. And so I guess I just need to get with them and make sure that they actually take it to them.
Well, if you're giving it to the constable could serve it, and then the constable makes the return, writes on that citation how it was served, and then that is returned and filed with the district clerk. And that's what hasn't happened in this case thus far. Yeah, posting it on whatever, Facebook or emailing it to them, things of that nature, not constitute sufficient service.
Okay.
So there was no reason to be setting the motions for default judgment, the motion for summary judgment when the defendants haven't even appeared in the case yet.
Okay.
So that's what, once they get served, and then the return will need to be filed with the district clerk, and at that point the court can determine whether there's been proper service and start computing the time for an answer date.
Okay.
But in the meantime, yeah, there's no need to send copies of all these emails and stuff to the court. In fact, we prefer you not send it to the court. And but if you have a plan for getting them reserved properly, then that's good.
Okay.
All right. So I'm not making any rulings today. I just wanted to make sure that you understood what was happening in the case. So that will, unless you have something else, that'll conclude our hearing. We'll go off the record.
No, that was it. I assumed that was the problem, but I've tried so hard, and I can't afford a service provider, and getting people to do it remotely, just me sending it to them has been so impossible that I've just tried to get them to actually answer by faxing it to them, stuff like that, so that we could actually skip over that. And they just, as soon as they realized it was a real lawsuit, locked down and started digging through things like discoveries and everything that the court has sent through their system. So we'll figure it out.
All right.
I appreciate your time, sir.
All right. That'll conclude the hearing. We'll go off the record.
All right. Thank you.
Leave the meeting.
Okay, let me pop up a window here, and I'm gonna just do some bullshit talking while it's still recording. Yeah, so I can't actually really agree with that, because if you go and look at the service stuff, they have had a service on them of the writ of mandamus. It's been served to all their email addresses, to their general counsel, stuff like that. Their general counsel has a fax of the petition for the suit. And the law has actually sent them copies of my discovery. If we check my emails, you can actually see in there where they've opened up like the discovery like 40 times in like a 10-day period. So they're obviously going through my discoveries and everything, and it starts bending it where, how am I supposed to have a fair trial? What are they doing with those documents? And we have no way of knowing, which is why at one point I did an emergency injunction to actually just go seize those documents. Like, if you're not going to go ahead and give me my trial right now and let me have my hearing, don't let them just dig through everything while they knowingly know there's a lawsuit that they refuse to answer to. There's several Supreme Court rulings that I've put in that stuff where it talks about things like they can't wait for proper service. They have a knowledge that they need to answer. They know that there's a lawsuit, and it starts ruining your ability for a free trial or like a fair trial because they now have far past the 30 days on their ability to do stuff. I have attempted a regular thing by sending a copy of the citation to the constables and stuff, and they won't serve it. So unless I actually pay for a service provider, I can't actually get service because nobody wants to do anything unless you go to their face and hand it to them and pay constable fees, which I can't afford right now. And so because of that, I'm just not ever going to do any kind of other actual services because it's bullshit to do any further service than that. I will go ahead and make copies of all that, and I'll send it down to that 5th Precinct and tell them, like, hey, they're saying that this hasn't been served. I need this to be reserved. And I'll specifically say reserved so that the record shows that. And I'm sure that they won't actually do it. I'll send a copy of what my bank account looks like to them right now and everything and let them know I have no available credit, no car currently, because apparently you have to have money at all to even get copies of those documents to send them. So if you are at a point where you can't even afford 50 cents, you're not able to access the court system. I don't know how they feel about these recordings because you're not really supposed to record courtrooms, but this is a Zoom meeting. I don't know. They put it on the record and everything. I hope they actually record these things instead of just doing plain old court reporting anymore. The court reporting probably still important just because you have the physical transcript and everything, but this video should be recorded on their end too always now. Technology's just advanced. There's no reason to get rid of the court reporter's job. Just make sure we reinforce everything with the the things that we do have. But I'll send all that stuff off to the constable and everything, and I probably won't get an answer back. But it'll be in a tracked email, which eventually will end up in all the evidence and everything. Still waiting on the Supreme Court ruling as far as I know. We could check it real quick while I'm on video. I'm sure they're going to be actually at least irritated that they haven't answered because there's too much evidence to show that they have a copy of the petition, that they have a copy of all that kind of stuff, and they're just sitting quietly not answering just so that they can drag it out and make it cost me more than it should, because once they're well aware, that should be it. I mean, what do you do after that if you can't afford the stuff? And they're just going to sit there and it's over an invoice that is thousands of days due, over a contract that we can prove was breached, and that after basically one day, I was like, F you, we're done. We're still, let me turn the brightness all the way down. It doesn't work well otherwise. We're still under review. But I mean, Santabella versus New York, the state has to maintain their contracts, and I flat out put in there stuff that, like, I will not accept this without this. And then I asked about it, and there's parts where I made comments on there, and within like a week, I'm like, no, y'all broke contract, we're done. And then we sat there, and I was like, dude, if we're going to keep doing this, we're going to do it on my terms, and this is how much it's worth to me. And for a good year and a half, 2 years, I was like, are y'all sure? And would send them updates like, hey, I don't think this is what you want to pay for this, but this is what it's worth. You can let me go at any time back in the prison, and I won't charge you a penny for this, up until about 75% of it was done. Then I was like, I'm going to at least want my back time. And then a little later, I was like, okay, I'm going to want my money too, up until this point. And there's just record after record of that. Every money order they cash on it's going to have additional terms and conditions here, and it has a list of those terms and conditions. They have it all on record. I sent a final invoice by certified mail asking for one to be put in my file and one to be sent to accounts payable, and they sent back a stamp saying it's in the file. And they didn't pay me or anything, so I waited until it got really close to the time that the thing could just be ignored and I wouldn't be able to take legal action, which is actually 2 days from now. So I started legal action back in January just to make sure it was on there in case any shot backs or anything from me filing wrong. So that's in there. And then after I served them in person and waited for 20 days, because we have a video of them holding a copy of the petition, and all of a sudden they don't want to do their names and stuff. The courts can say what they want, but I don't understand why they're not pissed off that a company is dodging a well-known petition that has been sent to their general counsel by a fax that they've had in person, that they've had sent by certified letter, that they, et cetera, because at that point there's literally nothing else I can do. I can't even pay the 50 cents to get another copy sent to have it sent to them by certified mail. I will also make a request for service again and submit that. But they're just working outside the court calendar right now is all they're doing. And basically they're allowing it even though there's no reason to. They say I can't serve them, but I've got emails where they say if you want to serve them. So basically they bullshitted me the whole way, and this is what happens if you don't have an attorney you can pay for. And by law, that's all 18% interest. They're going to try to argue their way out and say it's not a valid contract or anything. If that's the case, I didn't have a valid parole contract, and I had people barging into my house when they were not welcome in the middle of what I was supposed to be sleeping at night. They denied me medical care, all that kind of stuff. So we'll get all this up there, and parole is just going to look like shit once all this stuff is actually in front of a jury or anything. And I've already tried to sit there and offer them plea bargain or settlement agreements and stuff, and they just ignore me. Their only response after a few weeks was like, just so you know, this is in your file now. Like, I'm like, okay, I'm not on parole, I'm not in prison. So you're literally just so caught up on he's just an inmate, he's just a parolee, that you can't even realize I actually sued you. And they have a copy of that petition in the file that they put there that I didn't serve them, that technically Google would. So if I have to, I'll go to the Supreme Court of the United States over this one. I'm done. They have an obligation to maintain their contracts and do the right thing and to ease the court process. And here they are just making my life hard because they want to run like scared little bitches, is plain and simple. They don't want to be accountable for their actions while they demand everybody else be accountable for their actions even when they're doing stuff wrong. So, anyways, we'll get this posted up. And that's it.